good morning. And first of all, thank you so much to Kerstin and the KBR team. We're just super excited, and we'll dig in a little bit deeper into Synovus, as we get started. But no, my name is Casey Willett. I'm the retail market manager here in the Tampa market, as well as the regional sales and performance partner for the West Coast of Florida. So really looking forward to the content today, and again, we appreciate being part of the call today.
Thank you, Casey. Jason?
Yeah, Jason Seuss. Again, I echo Casey's statements. Definitely glad to be a part of the panel today and to be a part of this event. My name is Jason Seuss. I'm a commercial relationship manager, aka commercial banker, based here in the Tampa market, which is also our Florida headquarters here in downtown Tampa. So very glad to be a part of it. Thank you.
Sweet. Thank you, gentlemen. And now I want to introduce our managing attorney of the Tampa office and Kaye Rembaum partner, Kerstin Henze. Kerstin, please tell a little bit about yourselves, and then we can get started with the presentation on funding construction projects.
Hello, thank you. Thank you everyone for attending this morning and spending your time with us. I'm Kerstin Henze with the law firm of Kaye Rembaum. For those of you who are not familiar with the firm, our main office is in South Florida, in Pompano Beach, Florida, but we have since expanded and have offices in the Palm Beach Gardens, in Orlando, and an office here on the West Coast, located in Tampa. I'm a partner and managing attorney with the law firm, and I've been with the firm since 2010, exclusively practicing in community association law. Okay, so with that said, let's dive in. Share the screen. So here we go. I want to start by saying that, the information that we're giving here today is really, it's going to be very basic and general. Okay, so if you have any specific questions, definitely encourage you to speak with your association legal counsel. And if you don't have one, I welcome the opportunity to further speak with you about any specific issues you might have. So funding construction projects. First of all, I've identified here some of the some samples of large expenditures, large dollar projects that you might be facing. Okay. You might have emergency mitigation projects, whether it's water damage or as a result of hurricane damage. You might be looking at a project to address code compliance, or a 40-year recertification or a 50-year recertification issue that primarily would apply to those associations that are in the Broward and Miami-Dade counties in South Florida. You could be looking at a concrete restoration project as a result of maybe your milestone inspection or the CEUs. You could be facing fire life safety code upgrades, such as installation of an ELSS system in your condominium, or you could just be looking at, replacement, substantial upgrade building components. For example, if you have a seawall that needs restoration, or you have elevators that need to be modernized. Okay, so these are the type of projects that we're talking about today. Now, what could be the source of funding? Well, one source could be your annual budget, right? So depending on basically the scope of the project or the timeline, the board could just add basically the cost of the project as a line item on your operating budget. And then owners would just be paying for the cost of the project through their regular assessment payments, whether quarterly or monthly. That is less likely, of course, if you're having to do a large dollar project. The more likely scenario is that you would be adopting a special assessment to either pay for all or portion of this project. And then you also have your reserves, and then borrowing financing could be a last option that you might be considering. So I'm going to talk about each one of them in a little bit detail. All right, let's dive into reserves first. Okay. So first of all, you'd want to have a reserve study done. okay, regardless of whether your building is, over 3 stories or not. And we'll talk about the distinctions here in light of the CEUs mandates, but you want to have a reserve study done. And a reserve study basically is a study of the reserve funds that you will need for repairs or replacement of certain building components. Okay. Now, let's talk about CEUs briefly. In light of recent legislation, if you are a condominium or a co-op association that existed before July 1st of 2022, and you are owner controlled, you have to do a structural integrity reserve study. Okay, you have to do it by December 31st of 2024 for each building that is at least 3 stories or higher. Okay, and then every 10 years thereafter. So if you're in a multi-condominium situation where you have an association that manages multiple condominiums, and some condominium buildings are 3 stories or higher, and some might be less than 3 stories, then you are required to do the CEUs for those specific condominium buildings that are 3 stories and higher. Okay, now, if you are an association that manages condominiums that are less than 3 stories higher, okay, while you're not subject to the CEUs requirement, okay, if you haven't done a reserve study in quite some time, then it would be a prudent thing to do, okay, because what the reserve study essentially does is basically identifies what the useful life of your building components are, what is the remaining useful life of these components, the estimated replacement cost of these components, and then it'll provide you with a funding schedule of how much you will need to fully fund each year to make sure you have sufficient funds at the end of the useful life to replace your building component. Okay, so to be clear, okay, the statutory reserve requirements, okay, for non-CEUs, okay, they remain in the statute. They have not gone away. That is an obligation for every condominium association, whether you're 3 stories or higher, okay? So for CEUs, the statute identifies the building components that you have to fully fund reserves. I'm not going to go over them here, but essentially your roof, your structures, your plumbing. And then if you are a building that's less than 3 stories high, you still have an obligation to fully fund reserves for your 4 basic components: your roof, your painting, your paving, and then for any other building component that would require a deferred maintenance or replacement cost of $10,000 or more. So, for example, paving is one of those items that is not necessarily in the CEUs requirements, but if you are a condominium, you still have to fully fund for paving, okay? So you might have actually CEUs reserves and non-CEUs reserves, okay? Now, pooled and straight line reserves. For most associations, you will typically have straight line reserves. That means you will have reserve accounts for each reserve item, separate reserve accounts. You do have the option to pool reserves, okay? And you can talk to your accountant about that. But essentially, if you are a CEUs building, okay, you can pool your CEUs reserves. And you can also pool your non-CEUs reserves, okay? That is allowed. What you cannot do is pool your CEUs and your non-CEUs reserves, okay? So if you are in a building that's less than 3 stories high, obviously you're not concerned with CEUs, you can pool all of your non-CEUs reserves, okay? If you are in a building that's 3 stories or higher, you can pool your CEUs reserves. And then if you have non-CEUs reserves, you can pull those. You just can't pull them together. Now, if you are in a straight line method and you want to start pulling, okay, and there is a benefit of pulling, but if you want to start pulling, you do need a vote of the membership, okay? And the the voting threshold that you need to get is the majority vote of the voting interest. It used to be that you would need a vote of the majority of quorum, but the statute changed in the last legislative session and now requires a vote of the majority of the voting interest. So if you have a condominium, let's say with 100 units, to keep it simple, you will need a vote of majority of those 100 units. So it would be 50% plus 1. Okay. Now, the benefits of pooling reserves as a source of funding any project is that you can use any funds that's in the pool, okay, for any reserve item within the pool. And you don't have to pool all the reserve items, okay? You can decide, let's say, to pool reserve funds for, roofing or painting or plumbing, and leave the other reserve items, as a straight line reserve account. Alternatively, you can pull all of them. That's a business decision of the board. But if you do pull reserves, and let's say you have, roof replacement reserves and then painting reserves in the pool, and let's say, this year you absolutely have to replace the roof, but you just don't have enough funds allocated or in the reserve for roof replacement. Well, you can use funds allocated for the painting that's within this pool to fund the balance of your roof replacement project, okay, if there's enough. And you can do that without a vote of the membership, okay? We'll talk about alternate use of reserve funds, but that typically requires a membership vote, okay? With pooled accounts, you don't need a vote of the membership, as long as you're using those pooled reserves for items only within the pool. So that could be an alternative source of funding. Now, waiver or partial funding of reserves. For buildings that are required to maintain CEUs, okay? If you adopt a budget on or after December 31st of 2024, well, then unfortunately, you will be required to fully fund all CEUs reserves, okay? You will not be in a position to have owners waive or partially fund CEUs. But that's for budgets adopted after December 31st, 2024. What that means is that if you are able to get a membership vote, okay, to waive or partially fund those CEUs before December 31st of 2024, and then if the board adopts the budget with either waived or partial funding of reserves before December 31st of 2024, okay, then for your 2025 budget, you can still have waived or partial funded reserves. Okay, but that membership vote and that board adopted budget has to be done before December 31st of 2024. So if you're not ready to fully fund reserves for 2025, make sure you get that membership and board vote before this deadline. Okay. However, after December 31st, 2024, okay, so that would be for the 2026 budget year, you will be required to fully fund. Okay. For non-CEUs condominiums, okay, if you're not required to do CEUs, you still have the option to give owners the option to waive or partially fund reserves. Okay, so where this could be helpful is that, if you are looking at a major project coming up, right, and as a board, you're going to have to adopt maybe a special assessment, okay, and you rather have owners pay your special assessments, but you don't want to squeeze your owners to also have to fully fund reserves for that year, then you might, decide to present to the owners the option to waive or partially fund reserves for the coming year so that owners could have a little bit more breathing room, or perhaps so that the owners can funnel their assessments to pay the special assessments, okay? It is absolutely a business decision of the board if you want to give the owners that option to waive or partially fund reserves, okay? It is not something that the law requires, okay? Now, if you do decide to give owners the option to waive or partially fund reserves, you want to make sure that you only present one of these options to the owners. It's either waiving reserves or partially funding reserves, because if you put on the limited proxy or your ballot both of these questions, okay, now you're bifurcating the vote. And the vote that you need to obtain from the owners is a vote of the majority of the voting interest. So again, if you have a condominium with 100 units, the vote that you would need to waive or partially fund reserves is a majority of those 100, 50% plus 1. So now if the owners are having to vote on, one of the two questions presented on the limited proxy, you might actually not be able to get the threshold that you need. Okay. All right, then alternate use of reserve funds. Essentially, it's the ability to use your reserve funds for purposes other than what they were designated for, okay? For CEUs reserves, for budgets adopted on or after December 31st of 2024, unfortunately, the associations will no longer be able to use those CEUs funds for alternate purposes. That means that you're gonna have to use CEUs funds only for CEUs reserve items, okay? So you're not gonna have the flexibility of using those CEUs funds for other projects that you might not have been funding reserves for, okay? For non-CEUs reserves, you still have the option to have owners vote on using those reserve funds for alternate purposes, okay? So again, let's stick with the roof replacement scenario. Let's say you have to replace your roof this year because your insurance agent is telling you to do that. Otherwise, your premium is going to increase. You didn't anticipate replacing the roof this year, and so you don't have enough funds in your roof replacement reserve. Okay, but let's say you have some additional funding in your painting reserve, or you might have additional funding in your paving or any other reserve item. Well, you can have the option of dipping into these other reserves if necessary, okay, to fund the roof replacement project. Again, you will need a vote of the owners if you're going to use reserves for alternate purposes, okay? And the vote that you need is, again, a vote of the majority of the voting interest. And the important thing here is that you also want to get the membership vote before you dip into these reserve accounts. Now, everything I've discussed here concerns condominiums. For those individuals here attending that are with an HOA, okay, the big question here is whether your reserves were created by the membership. Okay, I know HOAs use the word reserve to sometimes mean, a contingency fund, okay? But if we're talking about, statutory reserves, okay, that's something that the membership needed to have established by a vote of the owners, and it required a vote of the majority of the voting interest. So the way you can confirm if the members established statutory reserves for your HOA is to look at your association official records. Okay, if you can locate the the notice of the meeting, the voting proxies, the voting ballots for that meeting, then it looks like you have statutory reserves. In that case, you have to fund and maintain those reserves in accordance with Chapter 720 of the Florida statute, which is very similar to how condominiums have to maintain and fund reserves. Okay, it means you can only use reserve funds for designated reserve items, and you cannot waive or partially fund those reserves except with a membership vote, and you cannot use those reserve funds for alternate purposes except with a vote of the membership. If you cannot find in your official records any documentation confirming that the membership established statutory reserves, then the case is that simply you don't have statutory reserves, and whatever funds you call reserves are likely just, contingency funds. Okay, that means that you essentially can use those funds for any bona fide association purpose. Doesn't mean you can use funds to, to host your next Christmas party unless you have specific authority to do that. Okay, but for any, repair, replacement, improvement project, they can be used without membership approval. All right, so moving on to special assessments. Now, special assessments can be a source of additional funding in conjunction with your reserves or in conjunction with, borrowing funds, or you can just adopt a special assessment without having to use these alternate funding methods. Now, the statute and your governing documents should give you the authority to adopt special assessments for any bona fide purpose. Now, in terms of the content and the timing of the notice, okay, both chapters 718 and chapter 720 are very specific about the process and what this notice of adopting a special assessment has to provide. Okay, so the notice of the board meeting at which you can adopt a special assessment has to identify that the special assessment is going to be considered, has to identify the estimated cost, and then provide a description, the purpose of the special assessment. Okay, so you could say, on June 1st at 10 in the morning at the clubhouse, the board's going to meet to adopt a special assessment for the purpose of funding, replacement of the roof of the building or the clubhouse, etc., in the amount of $150,000. That notice has to be either mailed, hand delivered, or electronically transmitted to owners. Okay, with electronic transmission, meaning via email. Okay, that if you're going to email the notice to owners, then it has to be to those owners who have consented in writing to receiving official notices by email. So if you don't have written consent from owners, okay, consenting to receiving official notices by email, then your email blast with the notice would not constitute as official notice. You would have to either mail or hand deliver that notice, and then as a courtesy, you could email it to the owner. Okay. Now, that notice also has to be posted on your condominium or HOA property at least 14 days prior to the meeting. And then the statute also requires that you have an affidavit executed by the individual that provided the notice, and typically to the secretary or your property manager. And you keep that notice and that affidavit as part of your official records. And the reason this is very important is that if an owner later does not pay, an installment of your special assessment, and you decide to lien and foreclose, you turn that file to your, to your attorney or to our firm, we will require you and request that you provide this notice and affidavit, and we will not proceed without it. Okay, because that basically is a defense that the owner can raise that you did not properly adopt the special assessment. And then the association's collection foreclosure action will basically have to be voided. You'll have to start from the beginning to the adoption of the special assessment. Now, limitation in your governing documents. Typically, it is a board decision, a board vote for adoption of a special assessment. Okay, so the documents typically give boards the authority to adopt special assessments when necessary for bona fide association purposes. But check your governing documents, because you might have language that requires membership to approve a special assessment. Okay, for HOAs, this is language that would typically be found in your bylaws. For condominium associations, that's language that you might it's typically found in your declaration, but it could be in your bylaws. Now, if you have language that specifically says that the owners have to approve a special assessment on any, improvement project, there is case law in Florida that has established a necessary maintenance exception. Essentially, if these funds are being used to fund a necessary maintenance obligation of the association, provided under the governing documents and the statute, then the association has a fiduciary, the boards have a fiduciary obligation to undertake that project and can assess without membership approval. Okay, that is precedence in case law that has already been established, okay, for condominiums and HOAs as well. Okay, now that is very different from the question of a material alteration, and I just kind of want to raise that here. Okay, material alteration applies in the condominium setting. Material alteration is not really a concept in HOA world, okay? But for condominiums, the statute is clear that if the association wants to undertake a material alteration to the common elements, then unless the governing documents provide otherwise, you need to obtain a vote of 75% of the membership to approve that material alteration. So how it could come up in a construction project is, again, with the roof, you have to replace the roof of the building. That is a necessary maintenance obligation of the association to maintain the roof. Adopting a special assessment to replace the roof would not require membership approval. But let's say you want to change the color or the style of the shingles. Okay, that portion is a material alteration. The division of condominium would consider that a material alteration. And so for that portion alone, you might need to get membership approval depending on what your governing documents provide. Okay, so if you're looking at that scenario, get with legal counsel so they can review your governing documents and your options. All right, now the board sets the terms of the special assessment. Okay, at some point, once you've decided, the project, the scope of the project, you've signed the contract, you've determined, the amount of your special assessment, and you're ready to adopt the special assessment. I encourage you to get with legal counsel to help you draft the motion that you should be reading at your meeting, and which eventually will be turned into the minutes, okay, for that meeting. You want to make sure your terms of the special assessment are very clear. For example, the roof replacement project will be paid, in 5 equal installments due at the beginning or on the first of every month. Whatever the terms might be, you want to make sure they're clear. You want to make sure that your motion reflects that each owner will be paying the special assessment according to their percentage of undivided interest in the common elements, whether that's based on the percentage of square footage of the unit they own, and that would be set in your declaration, or if everyone pays the same amount. You want to make sure that that's clear in your motion. You want your motion to also indicate what will happen if units are sold or refinanced before your special assessment is paid off. So if you have a special assessment where owners have to pay for 12 equal months and a unit is sold or refinanced, halfway, you want to consult with your legal counsel as to your options of what you want to happen at that point. And an option can be that you might want the balance of that special assessment to be paid off at closing, or you might want to have the buyer assume the obligation to pay off the balance of the special assessment. All depends on what your governing documents provide. Okay. You will also want to discuss with your legal counsel and make sure your motion also reflects what's going to happen if a foreclosing lender, if a lender goes through their foreclosure action, then takes title to the unit, okay, and this special assessment has not been paid off. As you might know, both Chapter 720 and 718 provide safe harbor. for first mortgagee. So if they take title, they would only owe either 1% of the note or 12 months worth of assessments. So you don't want this lender foreclosing and taking title to wipe off that special assessment. So you want to get with counsel to make sure your motion is properly drafted. All right. And then finally, we have borrowing and financing. Now, it's a board decision, board discretion, if you want the association to borrow funds, whether it's to pay for the entire project or you might want to borrow funds to, fund a balance of the project so that owners are not stuck with having to pay a large special assessment. Now, the authority for the association to incur debt should be in your governing documents. Typically would be under the powers section of the Articles of Incorporation or in your bylaws, okay? And if you don't see specific language of authority to borrow, then Chapter 617 of the Florida statute gives associations that authority. And Chapter 617 is the chapter that governs non-for-profit corporations. As you may know, associations are not-for-profit entities, okay? So they fall under Chapter 617 as well as Chapter 718 or 720, depending if you're an HOA or condominium. Now, board versus membership approval. Again, if you are considering borrowing, you'll want to get with your association legal counsel to confirm whether you need membership approval to borrow. If you do, there is no exception. There's no necessary maintenance exception in the law for borrowing. Okay, so the maintenance exception, the necessary maintenance exception is only for adoption of special assessments, but not for borrowing. Okay, so if you do require membership approval, then you'll want to get that approval first, okay, before you go on to sign your loan commitment and your loan document. And in fact, the lender is going to require you to confirm whether you need membership approval, and if so, whether you've obtained it, okay. Meeting notice. You'll want to also get with legal counsel. Well, first, you definitely want to get your legal counsel involved as early as possible in the borrowing, if you're considering borrowing, okay? But you want to get with counsel again to confirm what are the notice requirements for you to notice a meeting at which you're going to approve the borrowing, right? If you're going to be adopting a special assessment to pay off the loan, then you will likely need a 14-day notice. Okay, you'll need to mail that notice 14 days prior. Okay, also your motions. Your motion at which you're going to be adopting the borrowing. You want to make sure it specifies the loan amount, the name of the lender, the interest rate, the repayment terms, the terms of the loan and line of credit. You want to detail the nature of the renovation project, the total amount of the special assessment that you're going to be adopting to pay back those funds borrowed, okay? You'll want the motion to also reflect what will happen to the special assessment if the unit is sold before the special assessment is paid off, as well as what will happen if the lender forecloses and takes title to the unit, right? All right, and then I also just kind of wanted to point out some of the legal documents that you will be coming across if you do decide to borrow. You know, Jason's going to talk to you a little bit more about the process of borrowing, financing your project, and he'll probably touch a little bit on some of these. But from the legal perspective, you will have a commitment letter. Okay, now a commitment letter is a binding agreement between the lender and the borrower. Okay, so you will want to make sure that you have your legal counsel review this commitment letter before you sign it. Okay, because once you sign this commitment letter, okay, then it becomes binding, and all the loan documents are basically going to be drafted to conform to the terms and conditions of this loan commitment. So if you haven't involved your legal counsel in this process earlier on, you haven't really missed the boat yet, but you definitely want to get your legal counsel involved before you sign that commitment letter. Okay? There's going to be a promissory note, a loan agreement. You'll want to make sure that the terms are accurate, notice, opportunity to cure, any prepayment penalties. You want to review all those terms, make sure that they're accurate, okay, and reflect your negotiations. You will also come across a document that's called the Collateral Assignment of Rights to Collect Assessment and Lien Rights. Okay. First of all, if you take out a bank loan, that is not going to be considered an encumbrance on a unit if the unit is sold. Okay. It doesn't mean that this loan is hanging over that unit. Okay. Because essentially what you're going to be doing is you're going to be assigning to the lender the rights to collect assessments as your collateral. You're not giving them condominium property. You're just giving them the right to step in the shoes of the association to collect assessments and then to lien and foreclose on the unit if that loan is not paid back. Okay. So with this document, you want to pay particular attention to how the term collateral is defined. And again, this is where your legal counsel needs to come in. You want to make sure that collateral is narrowly tailored. Okay. Collateral really should only include all general assessments, except for those designated for reserves. And then any special assessments that have been adopted to pay back the funds borrowed for this particular project. So anything else other than these items that I've mentioned should not be included in your collateral. So any insurance proceeds or any special assessments that have been adopted to fund other projects should not be part of your collateral for this particular project. And then you'll also have closing documents. Okay, so again, this is why it's important to get legal counsel involved earlier on so that legal counsel can help you in preparing all these documents necessary for closing. Okay, you'll need to have minutes of meetings approving the loan, the special assessment, your construction contract. You want to have your board resolutions, counsel's legal opinion. Your lender, okay, before you close, will want your legal counsel to attest in writing to certain items. Okay, for example, if you have the requirement to get membership approval on the loan, they will ask for legal counsel's opinion as to whether membership approval was obtained. There's other items that legal counsel will have to opine upon. Lender will require insurance documents, association governing documents, contracts with your contractor, engineer, plans, specifications, your budget, permits, all these items. And then you will also have closing costs. You'll have association counsel fees, then there's going to be costs for recording, the loan documents, documentary stamps, origination fees, and there's going to be lender counsel fees. Okay. All right, that was a very brief overview of financing, borrowing, and I'm going to pass it on now to Jason to dive a little bit more in detail.
Sounds great. Let's take it. Oh, great job, Kerstin. And no, Taylor Swift tickets, as expensive as they are, they do not count as collateral. I just wanted to throw that in there because somebody joked about that our last time we did this class, and I thought that was kind of funny. So I just wanted to give Jason time to pull up his slides. So that's the reason for the bad dad joke. Over to you, Jason.
Okay, perfect. Can everybody see? Are we good?
Yes. Yeah, we're seeing it.
Okay, awesome. Really appreciate it. Casey, I'll kind of let you start off with the introduction here, and then I'll take it from there.
Great. Thank you. And Kerstin, such fantastic information. Thank you so much. And I learned a lot through the presentation as well. So thank you. And, again, thank you for the opportunity to speak with you all today. And, Synovus is, with what we're focusing on today, we do have 249 branches in a multi-state footprint, but kind of with the focus today being here in Florida, we do have 94 branches in Florida. So I'm sure there within most of the footprints of everyone on today, we have some Synovus coverage in your area. Very prevalent on the East Coast, the Gulf Coast, up onto the Panhandle as well, throughout the center of the state. And very strong in association banking and association lending. I know today's focus is mostly on the lending aspect, and we'll let Jason get into that. But we do have some really good, Kerstin brought up like the reserve accounts and things for associations. So, with those reserves sitting there, of course, the association is going to want to earn some interest on those reserves. And we have some really good, strong, reserve opportunities for those funds for associations. With that said, though, I know again today is the focus on the lending aspect. So I'm going to turn it over to Jason, who's our subject matter expert on association lending and commercial lending in general. So Jason, I'll hand it over to you.
Thank you again, everyone. And again, just another quick backdrop. I'm a commercial banker here in Tampa. Loan size, just from a perspective that what we would normally see through our group, can range from as low as 250,000 to as high as 40 million. Realistically, it probably falls somewhere in between for most of our loans. But when it comes to associations, I want to make sure I stress that it's a lot different than traditional lending. Kerstin hit on a lot of those differences on her last slide there. But the closest thing I can probably associate it with would be municipality lending. I mean, associations basically act as mini municipalities. They have quasi-taxing authority powers. You have elected board members from within. So that is a very unique aspect of associations. We're going to talk about types of projects that banks finance. We're going to talk about the typical requirements that the banks will look for, information that will be required for you to present to the banks, talk a little bit about loan structure, and then ultimately strengths and weaknesses that the banks will look for when you're going to request financing. As far as types of projects, standard capital improvements are pretty much the bread and butter of what banks will look at. Roof replacements have been mentioned, parking lot replacement, repair, painting, siding replacement, central mechanical system upgrades. Energy efficient upgrades is something that we're seeing a little bit more of. I know Kerstin also talked about elevators and seawall repairs, just common area renovations, landscaping upgrades, you name it. They're all pretty much going to fall into that capital improvement umbrella. Special amenity projects, I know there's a lot of changes in your world with the recent regulatory requirements, but you want a pool, get your pools built, get your tennis courts done, your pickleball courts, whatever it is that is going to make your residents happy. We're here to help you, build that lifestyle. I know associations, lifestyle is important. Banks are willing and would love to the ability to help there, and clubhouses, of course. So whether it's renovations or building a new clubhouse, that's definitely something we can look at. We're going to talk very high level. It's going to be very cookie cutter in terms of terms and everything, what that will look like. But know that when you're dealing with a bank, it's like a fingerprint. Everything's going to be a little different. Certain guidelines that we play in, but anything that you hear me say today, make sure you know that there is wiggle room. Everything's open for negotiation, but we try to stay in the borders as much as possible. As for the typical requirements, typically banks are going to want to deal with communities that have at least a minimum of 20 units. Risk distribution is a key reason for that. If you start to go any smaller, it just opens it up for risk because of the type of collateral that the bank will take. We'll talk about that here shortly. Most banks are going to prefer communities with 100 or more units, but this can depend on the institution. Some banks, especially smaller banks, feel very comfortable in the 40 to 50 unit community space. So again, make sure that you're having conversations with your banking institution before you start in. Down the path of financing to see what those requirements or what that appetite looks like. One of the big things that will come up will be delinquency thresholds. Most banks do not like to see unit delinquencies exceeding 10% of the total units. And delinquency typically will be viewed at anything exceeding 60 days. That again, it can vary depending on the situation, but the rule of thumb is 10% or less, or what banks will like to see. Another big one is occupancy requirements. 60% owner occupied is a big one. In the higher percentage, the less risk that is to the bank. And the reason is because owners, when you own a property and you live in that property, not that investors don't care about the community, but you're more vested than an investor would be. So if you start to see it creeping below 60% in terms of occupancy for owner occupied versus investor, that is something that can be a red flag or something that would require a little more scrutiny from the bank when you're applying for your loan. Ownership distribution. With that said, even in situations where you have high owner occupancy, an investor that owns 10% or more of the total units is something that will be looked at. Again, it's not a knockout. It's just going to be something that banks will want to get a little more knowledge or dive in a little bit deeper on. Information. This is the biggest one. I know it's a messy slide, but I want to make sure I kind of touch on these important pieces. Governing documents are huge. Articles of incorporation, declaration of condominium, bylaws, and the covenants, conditions, and restrictions are anything that this is really going to be where we hone in, especially early in the process. We need to understand the makeup of the board, how frequent the board elections work, the numbers of members, the length of service. All of these things are things that we're going to want to know. But Kerstin talked about this. This is why you want to engage legal counsel, because you need to make sure that you have the authority to enter into a borrowing relationship with the bank, and make sure you have the proper mechanisms in place for rule enforcement, dispute resolution. These are all provisions that lenders are going to look at for protections, and want to make sure that the board members that are involved in this, trying to acquire a loan, that they have the ability to sign off on it. And these are big things. There's a lot more due diligence on the front end when it comes to association lending than with most traditional products. As for internal documents, we're going to want to see the minutes for the board and owners meetings. This is going to give us some insight on how the association conducts business, and make sure that the proper permissions have been received in order to proceed with a loan request. Reserve studies. This is another big one. We want to understand what the long-term budget plan looks like, especially with the structural integrity reserve studies that are now required in Florida. Obviously, there's still some time this is getting implemented, but these will be things that you will see that banks require going forward. Reserve studies, the more current, the better. It just, again, when you're dealing in an unsecured situation where there is no property to take as collateral, the banks will rely a lot on these studies. Opinion letters from counsel are a must. These will be a very big part going forward. And to everything that Kerstin talked about earlier, it just provides us with assurances that you're able to pledge pledge the assignments of assessments, that your board members are empowered to borrow, etc. So you definitely want to engage legal counsel early and often when you're dealing with a loan. If not, it will be mandated at some point in the process. So just keep that in mind. Insurance documentation, although properties aren't taken as collateral, we still have to make sure proper coverages are in place in the event of a disaster, because we rely on the association dues for repayment of the loan. So that will be a big piece of that puzzle. So again, don't be surprised when when that information comes as part of your initial needs list. As far as what you can expect to provide from a financial standpoint or from a bank requirement standpoint, condo questionnaires, for condominiums will be a big thing. Every bank has a different form, but basically we're all trying to get that information, the same information. 3 years of prior tax returns and year-end financials. Depending on the loan size and the budget size, the types of requirements when it comes to the quality of financials may vary, but similar to engaging legal counsel, you're going to want to engage your CPAs and make sure you're dealing with a CPA firm that is specialized in association, has specialties with associations, and then make sure that you have the highest quality financials, that you can get, to make sure that it's accurate and banks are going to be comfortable. Again, this can vary whether it's a reviewed statement or whether it's a compilation CPA, but from a CPA, you want to make sure that you have good quality financials and year-to-date information. Banks are going to use that. Maybe not so much now this time of year, but as the year progresses, we're going to require year-to-date financials and a lot of cases pro formas. Put when applicable, because it's not always the case, but we want to make sure that that these numbers, we're going to see what your internal findings are like when it comes to taking this loan out, and the health overall, the association's cash flow, and then construction budgets, quotes, plans. We're going to ask for all of it. So again, these are a lot of things that are going to be required before we can even really get into the underwriting. Have a conversation with your lender. Every bank's a little different in terms of how they issue commitment letters, term sheets. We do full-scale underwriting before our commitment letter is issued. So a lot of this stuff we're going to ask for at our bank on the front end to make sure that we're comfortable with the terms that will be outlined in the commitment letter. So those are really, really important pieces. And again, I apologize for it being so messy. And this is a really, really important piece because this dictates the process from beginning to end. And it's very, very important. And it can feel a little overwhelming at first, especially for your property managers. If you engage them, we're going to ask for everything. So be prepared. Loan structures and products, common loan products. Again, the two most common types are term loans and non-revolving lines of credit. That falls into the construction bucket piece right there, the non-revolvers. There are other types of products that exist, but are more on one-off situations depending on the individual association's need. The great thing is loan amounts can be up to 100% of total project costs, and we can loop in soft costs, contingencies, closing costs. All of that can be packaged in. This is again different from something that you would see in traditional finance. If you've, I know we have board members on the line here. If you've had companies in the past that have taken out loans or commercial loans, this is a big, big difference, and it's great. That you can incorporate it all into that loan. Loans are fully amortized, so there is no balloon payments with association loans. Typically, a 36-month term is the norm, though again, depending on the project, they can go out as long as 10 years, sometimes 15 years, depending on the bank. But rule of thumb, you want to plan on a 32-month term. If the project is not going to be that long, the banks will monitor. Doesn't mean it's always going to be 36 months. If it's a 12-month project, we're going to try to align as closely as we can with the project completion date. But these are things that you can negotiate with your bank. So always keep that in mind. Banks are always going to try to tighten the screws to get as much, as much money back or get it repaid as quickly as possible without overstressing, the association from a cash flow perspective. But just knowing kind of where those guardrails are is great when you're negotiating with your bank. And then the collateral, assignments of current future assessments, assignment of special assessments, assignment of other assessments. Those are the most common pieces of collateral. But there are times where banks can take properties if there's a unit within a condo building that is used as an office that's owned by the association. It can happen. It's just rare that will be the case. So and then as far as loan products, I want to dive a little bit more of what this looks like from the non-revolver, which is also a construction loan. It's just different banks will have different terms, but every bank you deal with, when you take out a loan, they're going to require a depository relationship. It's basically another safeguard for the bank. So just be prepared. Auto pay is another thing that's very common, that the loan payments are taken out, monthly. Loans are monitored by the bank when you're doing a construction loan. So what does that mean? It means the project is funded on a timeline. Draw requests are given based on that timeline. So the bank, and you'll work with this will be ironed out as part of the the underwriting process, but getting an understanding of when a project reaches a certain deadline on a certain part of the project, and then the bank will disperse funds. You do need to have approved signers, board members. Typically, it's at least two. I guess everything's different. It all depends on the bylaws. but normally it's 2 board members at minimum will need to sign off on every draw request on the borrower side before the bank can even get to the point of releasing the funds. So it is a process that you will be engaged with throughout the terms of the project. Property managers are a very important part of this, but if they don't have the authority to sign on behalf of the association, they cannot sign off on the draw requests. Another thing that you'll see is the rates are variable during the construction period. This is very common. This is common no matter if it's an association loan or just a conventional loan when you're dealing in construction. And then it converts to a fixed loan typically at the end of that construction period. During the construction period, most times you'll be an interest-only payment during that period. And then when you flip to that fixed rate at the end of the construction period, it will be P&I, principal and interest for the remainder of the term. Again, what those payments look like will be outlined prior to closing, so you have an idea of what it looks like. But because it's fully amortized loan, it will be paid off. The term and the amortization will mirror each other. Term loans, typically for smaller projects, that those are going to be depository requirements as well, but they're going to be funded in full at closing. Most cases, they'll have a fixed rate. Principal and interest will start right away, and then they'll be fully amortized. Typically, no more than a 36-month term. But those are the 2 common products. Again, if there's a special situation, one-off, we can look at if it's a larger construction project, more for those special amenities. Clubhouses are a great example. You can see different terms, but again, this is very high level, very, what's going to be the type of structure that you see kind of down the fairway structures that we look at. Strengths and weaknesses, just so you kind of know where you fit. Obviously, usually it's a mix of the 2. The strengths are low renter to own ratios. The lower, the better. Significant reserves. If you have 70 to 100% of the project costs just in reserves overall, makes banks feel a little more comfortable. Stability and ownership. There hasn't been lots of high turnover in terms of unit sales. Again, that's all subject to change in market conditions, but that is a big part of what banks will look at as a strength. Tenured board, same property manager for years. That's a big piece. Quality interim financial reporting. Again, engage your CPAs early and often, and make sure you've got good quality financials. That is a big piece. And going forward with these new requirements that the state has put out with the new laws in place, you'll only see that tighten. We like to see previous experience with similar projects. And then sound budgeting practices. As for weaknesses, there's a lack of a firm grip on collections. That goes back to the delinquency rates we were talking about earlier. If there's been a lot of deferred maintenance issues where cans getting kicked down the road, that's not, that's going to make it a little more challenging when it comes to securing that financing. High special assessment amounts relative to market value. Again, putting that stress of a high special assessment on your owners. It's just a higher risk situation. Your terms are not going to be as favorable. It's going to be harder to secure financing. And then the high ratio of investor-owned units. It kind of goes back to what we've talked about a few times. Any association that with less than 100 units is deemed a little bit higher risk. Again, that's more of a bank-to-bank appetite. But just keep in mind, it's not a knockout. It's just something that is deemed a little higher risk in terms of underwriting for underwriting purposes. Unprofessional management. If this kind of goes back into same property manager bucket, or if there's lots of different property management companies that have been engaged, or they're just difficult to work with. From a reputation standpoint, banks, will have an idea of certain property management companies just based on the experiences throughout the footprint. So just keep that in mind. You always want to have, surround yourself with professional, good quality, high quality property managers. And then ultimately a weakness would be just declining real estate values in the area. So that's a little bit less out of the control of the association, but it is something that is factored into underwriting overall. So keep that in mind. And then, in conclusion, I want to say that you want to find the right partners. I cannot stress this enough. And this goes for any company I ever deal with. you want to make sure, especially in the association space, you're dealing with specialized CPA firms, specialized law firms, which are even harder to come by. So KBR is a great example of a great partner that you would want to engage, again, prior to even getting into requesting a loan. Both of those partners are big. Insurance partners are big, making sure you're surrounding yourself with good insurance partners. And then finding the right bank partner that lend in the association space. This is a product that you're not going to find at every single bank. Banks are going to be either all in or all out. And some banks, there's been a lot of acquisitions in our space. I mean, I don't think Synovus historically was big in associations, but we've acquired banks throughout our years, or 100 plus years in existence, that did play in it. And we get that familiarity with underwriting, associations. We love it. It's something that we are very, very comfortable in. And based on the states that we play in, we see a lot. So it's something that we love. I know we're touching at everything at a very high level. If you ever have any direct questions or one-offs, my contact information is right there. That's my cell number. Feel free to call me, text me, or email me or Casey anytime. We would love the opportunity to at least vet out and see if we can help out or help you structure a deal with your current bank and make sure that what you have or your terms are what we would see or what we think are competitive for the market. So with that said, I think that kind of touches, that hits everything I wanted to talk about.
See here. Question from Stephanie. Can't buildings under 3 stories still waive full funding of reserves? Yes, that is still an option for condominium associations that manage buildings 3 stories or under 3 stories. But again, the waiving of fully funding reserves still has to be presented as an option to the owners, and the owners have to approve the waiver by a majority of the voting interest. Okay.
I'll take a question here real quick. It was
Go for it.
It looks like, let me see. Okay, it was from Amy Thomas regarding how banks regard occupancy when there's seasonality within a building. That's a great question, Amy. What I was talking about earlier when it comes to owner occupancy, it's just kind of a rule of thumb. It doesn't mean that's how it has to be. Obviously, we're in Florida, seasonality is a thing. It's just understanding. So you'll get a little more scrutiny around that question, and it will trying to get the understanding of, is it 6 months on, 6 months off that it's rented out, and the owners are here for 6 months, those types of situations. But banks just want to understand. It doesn't even, sometimes it won't even fall in as an exception, an underwriting exception, if we get a good understanding on that. And that's a great question, because it does happen a lot here in Florida.
Okay. Let's see. A question from Pearl. I guess there's a community with 10 3-level buildings and 32 level buildings. And the question is whether they're not considered for CEUs. So if you're a condominium association that manages multiple, condominiums or multiple buildings, CEUs requirements apply for those buildings that are 3 stories and higher. So if you have 10 3-level buildings, you need to do a CEUs for those buildings.
It looks like Doreen Colquitt,
Okay.
asking in regards to having an emergency line of credit in place, and I think that's definitely a great best practice. Kind of having that line of credit in place prior to, because as you mentioned, you could have the money for the repairs and things sooner. Again, you still need to go through that same process that Jason went through in regards to obtaining the line of credit, but then once it's in play, you have that available for those emergency needs.
Merlin, must the affidavit of posting be notarized, or can it be simply stayed under penalty of perjury? No, an affidavit has to be notarized. So there should be a notary certificate in order for it to be valid.
You guys go ahead.
Yeah, there's one from William Conley, and he says, Casey, can you expand on the SA requirements relative to market value? I'm assuming by SA means the special assessments. We don't look at necessarily market value. The way we look at it is strictly on cash flow. So depending on the amount of the project and the special assessment amount, what that would have to look like in terms of the amount each unit would be paying, The ratios, and I don't want to get too technical, it's kind of 1-to-1. I mean, we know it's a little different than if we're dealing with an operating business, but ultimately, I mean, it kind of depends on the amount of the project, the amount of the units, and how much of a percentage increase it's going to be, that special assessment would be when it comes to what the owners are already paying in dues. So it's more of a specific site by site type of situation, but I want you to, it's not, we're looking at strictly cash flow. It's just whatever makes the cash flow work is what we care about, since that's our main means of repayment.